Good evening to you. Yesterday, by oversight, we missed 3 or 4 amendments as per the Amending Act 22 of 2002. They are that whenever a claim petition is filed under Order 21, Rule 97 to 101, whenever an appeal is filed, it has previously, under the old law, it was 30 days period. Within 30 days, you must file an appeal. But now in 2002, they have enhanced it to 60 days. That is from the date of order, 60 days period is given to prefer an appeal against a claim petition. So previously it was 30 days and now it has become 60 days. Then the next amendment that was brought about was in one not that is the introduced section 100A, whereby they said that there is no further appeal from a judgment of a single judge of the High Court. That means LPAs which were already granted earlier, that is what is called letters patent appeal, has now been abolished or repealed. And once a single judge of the High Court passes an order, you have to only go to the Supreme Court. You cannot file an LPA under 15 of the letters patent. So letters patent appeals have now been repealed and it has been removed from the statute book under section 100A. Then the next amendment that was brought about was by introducing section 101, which says that all appeals against a money decree which is less than 25,000 rupees, no appeal lies. It ends with the district court. So no appeal lies against a judgment where the money value is less than 25,000 rupees. Now no appeal lies against that. That is the amendment that has been brought about by 101. Then the next thing which I did not, by oversight, discuss was the caveat petition. That is 148A, which was introduced by the Amending Act 46 of 1976, which says that the opposite side, to prevent ex parte orders being granted, can file a caveat saying that please don't issue any stay orders without notice to me or to my advocate. And a copy of the caveat is served on the other side by registered post, and the postal receipt is filed along with the caveat petition. Then the advantage of filing a caveat petition is you can prevent a stay order being taken from the court behind your back. That is why it was introduced. 148A is a petition which you file. It's called caveat petition, CAVEAT, caveat petition. It was not there earlier, but it was introduced by the Amending Act 46 of 1976 in 1976. Then the question arises, once a caveat is filed, what are the consequences? That is, in case the other side files a suit or files an appeal, the question is no ex parte orders will be granted without notice to the other side, that is a caveator, through their advocate. Then the question arises, sir, what is the court fee you pay in a caveat petition? Please remember, you search the Court Fees Act, be it the Andhra Court Fees Act or the adapted Telangana Court Fees Act, you will not find any provision in the Court Fees Act which says under what provision court fee has to be paid. Please remember, again I repeat, the court fee has to be paid under Rule 295 of the Civil Rules of Practice. The petition has to be filed, and the court fee has to be paid under Rule 205 Civil Rules of Practice. Again, I repeat, it is Rule 295 Civil Rules of Practice. Then, in the Civil Rules of Practice, affidavits are also discussed. Actually, what is the exact meaning of the word affidavit? Affidavit means any statement or averments that are made in the first person under oath, solemnly under oath, is what is called an affidavit. And affidavit normally is a statement of facts which are made in an interlocutory application. Wherever you file a petition, it is to be supported by an affidavit. And normally, the person who furnishes the affidavit is called the deponent, DEPONENT. Deponent means one who deposes to the facts in the first person in an affidavit is called the deponent. Deponent. And if you see the other side, it is sworn and signed before me on this, the day of so and so, whatever date may be. And please remember, because of the repercussions which we are having under the Advocates Fees Act, Advocates Act, as well as the Bar Councils Act, we don't normally don't attest an affidavit without it being identified by the advocate who is appearing for the party. Why? Because you do not know who the party is. You do not know who signed the affidavit. You do not know who deposed the facts. And you do not know the identity of the person who has deposed the facts and signed the affidavit as a deponent. So it is better and advisable that you must get it identified by the advocate who is appearing for the party, so that you absolve yourself from any liability tomorrow to say that you have attested a forged affidavit or a forged signature affidavit. So that is the reason. Don't blindly sign an affidavit without it being identified by the advocate concerned who appears for the party. Then here a distinction has to be made. That is, to as far as Hindus are concerned, we Hindus take oath and we depose under oath. But as far as a Muslim is concerned, under the personal law, that is what is called the Shariat, a Muslim does not take oath. A Muslim only affirms to the facts. And in those cases, you will only say solemnly affirm and state as follows. Then, in the end, you don't mention the word deponent. We mention the word affirmant. That is a person who testifies saying that the facts mentioned above are true and correct, or affirms that it is true and correct. He is called the affirmant. And then when you write on the other side, you say affirmed and signed on this day of so and so, and get it identified by the advocate who is appearing for the party, and then you attest the affidavit. So this is what I missed when I was lecturing. It is only a pure mistake, sir. Please pardon me for that. Then we got one more thing which we have not discussed, was Section 9. Section 9 is, it says, it talks about Lex Fori. Lex Fori is law of the land. Wherever the cause of action is accrued, the suit has to be filed in that particular place. That is what is called Lex Fori. Lex space Fori, Fori. That is, it should be filed in the forum which has got the authority to try and entertain that matter. Then, if you see Section 9 of the Civil Procedure Code, it says all suits of civil nature can be filed in a civil court unless expressly barred. Why? Because I told you also in the earlier lectures, now we are in the era of specialization, and much of the work of the civil courts have been taken away by constituting various tribunals. For example, all matters arising under the Cooperative Societies Act or the Housing Societies Act, or any matter concerning a society, you cannot go to a civil court. You have to go to the Registrar of Societies, or you have to go to the Cooperative Tribunal which is constituted. That means a civil suit cannot be filed. There is to be precise, it is Section 61 of the Cooperative Societies Act says that all matters relating to a society, the jurisdiction of a civil court is barred. Then next we go to the service tribunals which are constituted. For example, you have got the disciplinary proceedings tribunal, which decides the issue of discipline or otherwise, and it is a special tribunal which is constituted to decide matters. You cannot go to a civil court as far as disciplinary matters coming under the purview of the disciplinary proceedings tribunal. Then you have got the Small Causes Court Act in the metros. They are the courts which are constituted under the Provincial Small Causes Court Act, where they decide matters of small cause nature, and preferably all matters arising in appeal, in rent appeal under Section 20 of the Rent Control Act, or municipal appeals which you file against assessment or demands made by the municipality. Then all insolvency petitions, that is what is called under the Provincial Insolvency Act, is filed before the additional judge, city small causes court, where in twin cities or metros. But in the districts, it is filed before the sub court or the Senior Civil Judges Court. But you cannot file a civil proceeding as far as matters arising under the Insolvency Act. Then we come to an enactment which is feeding most of our advocates today is the Family Courts Act. Are all disputes between husband and wife or concerning a family arising either under the Hindu Marriage Act 1955, Special Marriage Act of 1954, Indian Divorce Act as amended in 2001, or any Parsi marriage, Christian marriage, so on and so forth, it is only the family courts which can try the matter. Earlier, before the family courts were constituted, we all matrimonial matters used to be filed before the subcourt. Subcourt means senior civil judge. But now, after the constitution of the family courts, all matters arising out of marriage or in between the family members has to be filed before the family court. Then you have got a special enactment called the Guardian and Wards Act or the Hindu Adoption and Maintenance Act. Please remember, a court is earmarked for that purpose, either the family court or the district court where it has to be filed. Then all matters arising under the Arbitration and Conciliation Act, there all proceedings cannot be filed in a civil court, but it has to be submitted to arbitration, or you must ask the High Court under Section 11 of the Arbitration Act to appoint an arbitrator to mediate and decide the dispute. So all matters arising under the Arbitration and Conciliation Act has to be filed before the arbitrators, and the only power which is given is the High Court has got the power under Section 11 to appoint arbitrators. Then the next question is, as far as arbitration matters are concerned, when you want to protect your interest, can a suit be filed for injunction under the provisions of the Specific Relief Act or the Civil Procedure Code? Please remember, there is a special section called Section 9, which is a protective section. All matters relating to arbitration, where you want to take an injunction, you will have to go to the concerned court, which has got the portfolio to issue injunction orders. But under section, as far as Section 9 is concerned, it is not permanent in nature. The proceedings will have to be terminated or closed before 6 months, within 3 months. Then earlier we used to have what is called arbitration. Law of Arbitration and Conciliation Act prior to 1996. Under that, the procedure that was followed is first and foremost is that you must file an arbitration proceeding, and the arbitrator is appointed, and the arbitrator gives an award, and then the award has to be filed into the court, and then you must make it as a rule of the court, and then only it is enforceable. But please unmute, please. As Pulanagar, please. So as far as now the present new act is Arbitration and Conciliation Act, it is said that the award that is passed by the arbitrator is enforceable forthwith, and once you file it before the competent court, the court can execute it as if it is a money decree. That is, all the provisions of Order 21 applies in such a case. So now no need of getting it converted into a rule of the court. That is the state change that has been brought about as far as the Arbitration and Conciliation Act is concerned. Then we go to another enactment called the Societies Registration Act. Whenever there's a dispute between a member and a member, members and members, member and the society, and society against the members, then in that particular case, it says a civil court is barred from entertaining any matter relating to a society which is registered under the Societies Registration Act. Then in that case, it is only the principal district court or Under the Arbitration and Conciliation Act, you have to ask for arbitration. So slowly, what happened was the jurisdiction of a civil court was removed, and you can't file a civil suit. Then we come to the chit funds. Most of the chit fund companies used to earlier file civil suits before the civil courts and pay the necessary court fee. Now the Chit Funds Act has been amended, whereby they say all matters relating chit fund companies will be decided by a special tribunal, that is by a registrar, appoint a registrar deputed by the registrar of societies. As far as every financial institution on the chit fund side is concerned, a civil court jurisdiction is barred as far as bringing suits before the civil courts as far as chit fund companies are concerned. But as far as the execution procedure is concerned, it is said execution can be conducted only in a civil court. Only EPs are filed in a civil court for execution. Then we have got what is called service tribunals. Service tribunals, of course, unfortunately, in Telangana, we had the Telangana, those days it was a composite Andhra Pradesh state, it was called the APAT, that is Andhra Pradesh State Administrative Tribunal. Now, all matters arising out of service matters regarding state employees, there is no tribunal. You have to go to the High Court under Article 226 or 227 and agitate your matter there. Then we go to what is called labor disputes. What are labor disputes, sir? All disputes arising under the Trade Unions Act or the Industrial Disputes Act. There are special tribunals constituted for the purpose of disposal of those matters. They are called labor courts or they are called industrial tribunal. So, no matter arising out of the labor laws can be brought before a civil court. The jurisdiction of a civil court is ousted and no civil proceeding can be initiated. Then, sir, you have got what is called value added tax. Now, the latest one is VAT or VAT as they call it. Any matter that has to be agitated under that relevant provision has to be filed before the VAT tribunal or the value added tax tribunal and not before a civil court. And all matters arising out of the Income Tax Act, Wealth Tax, so on and so or the sales tax has to be filed before the Industrial Tribunal. I'm sorry, Income Tax Appellate Tribunal or before the ITO, or then the appeal lies to the Income Tax Appellate Tribunal or the Commercial Taxes Appellate Tribunal. So, like this, what has happened is slowly the jurisdiction of a civil court is ousted, and now more encouragement is given to the tribunals where the litigation is not prolonged for a long duration of time and it is disposed of immediately or within a time span, limited time span. So, Section 9 says all suits of civil nature can be filed in a civil court unless expressly barred. Then we go to Section 10. Section 10 deals with what is called res sub judice. Res sub judice, that means res means thing, sub judice, pending adjudication. Res sub judice, that means pending adjudication. Suppose, let us say, a case has been filed before a superior court, be it the senior court or the district court, and in the meanwhile, it is a comprehensive suit that is filed before a superior court. In the meanwhile, another proceeding is initiated regarding the same subject matter before the court below, which is subordinate to the superior court. Then, in that case, the question is the lower court or the court which is inferior or subordinate to the original court has to keep the matter stayed till such time the competent superior court disposes of the matter. This is what is called res sub judice. Suppose the matter is pending adjudication before a superior court, the courts below which is subordinate to it has to keep the matter in suspended animation till such time the superior court decides the matter. That is what Section 10 says. Am I making myself clear to you, please? Not much of discussion can be entertained regarding this. But next one section is very, very important. That is what is called res judicata. Res judicata, RES space judicata, JUDICATA. Please remember, first and foremost is, before we go into the theoretical part of it, we must know the meaning of res judicata. Res judicata means, res means thing, judicata means adjudicated. Thing already adjudicated is the provision called res judicata, and it is incorporated or discussed in section 11 of the Civil Procedure Code. What do you exactly mean by res judicata? If you read section 11, I told you also, when you read a section, read it objectively and don't read it subjectively. I'll go one by one. Section 11 says, where a right to property, again I go slow, where a right to property is directly in issue between the same parties litigating under the same title, and it is filed in a competent court of competent jurisdiction, and it has been heard and disposed of, it cannot be reopened. But there are two maxims which govern res judicata. One is what is called. Please unmute, please.
Please mute yourself. Keep your speaker and mute. Vedanarayana, you do.
Vedanarayana garu.
See, as far as res judicata is concerned, it is based on two Latin maxims which says interest republicae, A-E-S-T, fini, F-I-N-I-T, then litum, L-I-T-U-M. That is the first maxim. I will explain it also. Don't bother about it. The second maxim is ex debito bis vexari pro une et edem causa. What do you mean by interest republicae esse finilitum? Interest of the state is to put an end to the litigation at some stage or the other. There shall not be any endless litigation.
Alright, just muted everybody. Sir, nakal mute, unmute cheyandi. Sir, nakal mute cheyandi, unmute cheyandi. Alright.
So first one is interest republicae esse finilitum. Interest of the state is to try to put an end to the litigation at some stage or the other. There shall not be any endless litigation. Yes. The interest of the state is to put an end to the litigation at some stage or the other. There shall not be any endless litigation. I tell you the reason why. After all, we are all mortals. And please remember, what was 10 years ago may not be the same scenario today. Because all of us have some health problems. And sometimes, physically and mentally, we may be incapable of deposing or stating what we have stated earlier. Once a witness gives categorical evidence earlier and it has been heard, subsequently, let us say he has become a paralytic and he has lost his power of speech. Then, in that particular case, it says that you cannot trouble him again and call him to the witness box. So, and you cannot go on with the endless litigation forever. After all, that is not the correct maxim as far as we advocates are concerned, sir. Because we rely on the motto saying that long live litigation, because we live so long as litigation lives. God has created opportunities for all of us. How we utilize the opportunities, how we make money, it is our own technical know-how. So interest of the state is to see that somewhere or the other a litigation has to be plucked. That is the reason why various amendments have taken place, whereby they say you cannot go on and go on and go on forever. That is the reason the interest of the state is to see that the litigation is put to an end somewhere or the other. I'll again cite one thing, sir. It's something like saying, like you cannot make a dead man alive, isn't it? You don't have the magical powers whereby you can just apply some vibhuti or something and say the dead man will come alive. We don't have the spiritual powers, or we cannot make a dead horse alive. So what happens is, whenever a matter has been decided by a civil court at some stage or the other, it has attained finality. There cannot be endless litigation, prolonging the litigation again and again and again. Why? Because at the time when the evidence is given, the witness may be having a good health, but when the later on a later litigation comes, the witness may not have that much of health, or physically or mentally he is not in a position to come and give evidence. That is the reason the first maxim is interest republicae esse finilitum. Then second maxim is ex debito bis vexari pro une et tedem causa. I'll give you the spelling also. That is, there is ex debito, ex space debito, debito space bis bis space bis space vexari vxari vxari, then pro space une unet et edam eadm space causa causa. What is the meaning of this? That is, don't vex a person, don't trouble a person for the same cause over again. Don't trouble a person, harass a person for the same cause over again. Here, correspondingly, in the Constitution also, you have got a particular article, Article 20, 21, and 22, which says the doctrine of what is called double jeopardy. You cannot punish a person for the same cause over again. And in the criminal law also, if I'm correct, it is 405, 404 and 405 of the old act, CRPC, where they say authorify convict and authorify acquit. Where a person has been tried of a particular offense, he has been charged and he has been convicted or he has been acquitted, you cannot make him liable for the same charge and launch a second prosecution as far as the same set of facts is concerned. That is what is recognized in CRPC also. In Constitution, when we have the Articles of Fundamental Rights, or Part 3 of the Constitution, it says, as far as rights of personal liberty is concerned, it says once a person has been convicted or acquitted, you cannot try him again, because you cannot have two prosecutions for one single offense. That's what is laid down in the Constitution as well as in the CRPC. But here, ex debito bis vexari pro une et tedem causa. That means you don't trouble a person for the same cause over again. That means where he has already given his evidence, where he has been elaborately cross-examined, where he has been tried by a competent court of competent jurisdiction, and the dispute involves a common question which has already been adjudicated by the court, you cannot trouble him again, ask him to come to the witness box and depose. So that is what is called ex debito bis vexari pro unit et edam causa. That is, there must be an end to some litigation somewhere or the other, and you cannot cannot try to trouble a person for a cause which has already been decided and attained finality up to the superior court. So these are the two maxims. Am I making myself clear to you, please? Now we come to the theoretical portion of section 11. I'll go slowly, please. Where a right to property is directly and substantially in issue. Where a right to property is directly and substantially in issue in a former suit which has been filed in a competent court of competent jurisdiction and the parties are litigating under the same title, and which has been heard and decided, a fresh suit cannot be brought for the cause over again. Again, I repeat, where a right to property is directly and substantially in issue in a former suit between the same parties and litigating under the same title and filed in a competent court of competent jurisdiction, and it has been heard and decided, it cannot be reopened again. What do you mean? Let us go sentence by sentence. Where a right to property is directly and substantially issued. Let us take the case of a partition suit. There are only two contingencies in a partition suit. One is what is called the status of the family, the status of the person who is suing, whether he is a son or daughter. Then he alleges, sir, it is a joint family property. That is a proportionary property as far as Hindus are concerned, and as far as Muslims are concerned, it is called the Matruka property. Matruka means which is inherited or which is a property belonging to the ancestors. Where a right to property, one party alleges, sir, it's a proportionary property, or it's an ancestral property, or it's a joint property. Then second one is where a right to property is directly and substantially issued. What is the issue here, sir? Whether it's a joint family property or whether it's a self-acquired property, right? Then between the same parties, that is, parties must occupy the same status as a plaintiff and the defendant. Where in a former suit is earlier suit, and then they must be litigating under the same title. Here there is no dispute as far as the property is concerned. What is in dispute is the character, whether it's a joint property or it's a property which is a self-acquired property. Am I making myself clear to you, please? That is the issue which has to be resolved. Then between the same parties, that is where a right to property is directly and substantially in issue in a former suit between the same parties litigating under the same title, and it is filed. Am I making myself clear? And it is filed in a competent court of competent jurisdiction, and it has been heard and decided and attained finality. Then in that case, it cannot be reopened again. Again, I repeat, where a right to property is directly and substantially in issue in a former suit between the same parties litigating under the same title and filed in a competent court of competent jurisdiction, and it has been heard and decided, it cannot be reopened again. Am I making myself clear to you, please? This is res judicata. Again, I repeat, where a right to property is directly and substantially in issue in a formal suit between the same parties and litigating under the same title and filed in a competent court of competent jurisdiction, and it has been heard and decided. That means it cannot be reopened again. That is why it is said res judicata. Res judicata means resting. Adjudicata means adjudicated. A matter that has been already adjudicated cannot be reopened again. That is what is called res judicata. Then the question arises, sir, who are bound by res judicata? Normally in the law of contracts, we say previous to the contract are around bound. But here, please remember, the explanation that is given to section 11 says, not only the party, but his successors in interest, his transferees in interest, his legal representatives who come later on, or the transfer, or let us say the assignees who come later on, or the executors who come later on, all of them are bound by the decision already rendered regarding the same property in a former suit. Though you may not be a party, but still, since you succeed to the rights of your transferor, whatever the transferor was bound, you are also bound by that. Am I making myself clear to you, please? So the law of privity of contract does not apply as far as res judicata is concerned. It binds not only the person concerned with the litigation, but also his successors are also bound. I'm not for a moment saying only plaintiff. It also means the defendant. The explanation that is given is even the transferees in interest or the legal representatives or the assignees or whoever acquires the property later, the incidence of the former suit which has been decided is also binding on them, though they are not parties to the former suit. That is what is res judicata, sir. Then we go to section 11.4, which talks about constructive res judicata. Constructive res judicata. Here, res judicata is section 11. That is actual res judicata. But even though it may not be brought to your notice, but law presupposes that you have notice of those facts, then it is called constructive. For example, you know the difference between notice and constructive notice. What do you mean by notice? Facts which are directly brought to your knowledge is what is called notice. Constructive notice is, though you do not have knowledge of those facts directly, law presupposes that you have knowledge of that. For example, suppose a document is registered as per law, then registration of a document amounts to constructive notice. Why means constructive notice? Means where you do, even though you may not have knowledge of the facts, law presupposes knowledge. That is what is called constructive notice. So registration of a document is constructive notice of the facts mentioned earlier. So here, coming to section 11.4, it means all grounds of attack, please bear it in mind, all grounds of attack and defense which might or ought to have been taken, if not taken, is deemed to be waived. Again, I repeat, all grounds of attack which might or ought to have been taken, if not taken, is deemed to be waived. Again, I repeat, all grounds of attack and defense which might or ought to have been taken, if not taken, is deemed to be waived. What do you mean by this? For example, you have got the various defenses that are available to you under the various laws. Under the law of contracts, you know, discharge of contract, where you can exonerate yourself from the averments made in the plaint. For example, doctrine of frustration, novation, remission, rescission, then alteration, modification, and so on and so forth. Then, in that particular case, these defenses you have to take in your written statement. If you do not take it, the court will not permit you to take it in a subsequent suit. So, all grounds of defenses, I put it that way. So, whatever defense you could take, which you have to take under the law, if you do not take, you cannot take it later. Suppose, let us say, here there are various defenses under the various laws. For example, under the law of contracts, even in the Companies Act, you have got the defenses open to you. What is called the Lakshmana Rekha as far as the company is concerned. Here, you say that you have taken all steps possible. You got the memorandum and articles registered under the Companies Act, and you have also got the prospectus registered under the Companies Act, and you have also got the charges noted in the Register of Companies, and the shares or equity shares which you have announced, you have done it with the permission of the SEBI, or all the steps you have taken. And suppose the other side complains, sir, these are the steps which are not taken. And as a matter of defense, you can take all these things saying that under the relevant provision, under the Act, you have taken all those precautions, and these defenses you are bound to take in your written statement or in your counter which you file before the appropriate authorities. If you do not take it, the court will deem it that whatever has been decided earlier is final and you cannot take it at this stage. Then we go to what is called all grounds of attack. What do you mean by all grounds of attack? You know, under the specifically fact, whenever a suit is filed for specific performance of a contract, then you have to take an attack by saying, "Sir, I am ready and willing to perform my part of the contract. I have taken all steps which a prudent man would take in respect of his own things, and the other side is the wrongdoer, sir. He has not fulfilled the terms of the contract. He has committed a breach thereof." These are all the things which you have to take as far as the grounds of attack is concerned. Then you know the Benami Properties Transfer of Properties Act, where it is said, it has been made very, very clear that whomsoever's name is mentioned as the owner of the property is the true owner of the property. But under Section 3 of the Benami Transfers Prohibition Act, it is laid down that you have to show the means and say, you are the person who footed the consideration, you are the person who spent the money, you are the person who spent the money to acquire the property. Nominally, it is kept in the name of your wife, and your wife is not the owner, but you are the owner, and you want you to be declared as the true owner of the property, and the actual person whose name is mentioned is the Benamidar. These are the various grounds of attack which you have to take, sir. If you do not take it, later on you cannot do it. That's what constructive res judicata means. So it is only 2 lines rule. It says all grounds of attack. Please again I repeat, all grounds of attack and defense which might or ought to have been taken, if not taken, is deemed to be waived. So the question is, not only when you file a plaint, not only when you file the written statement, you are supposed to take all grounds of attack to attack the other side. And
Recording stopped.
And as far as the defendant is concerned, whenever you want to take a defense under the various laws, they have to be specifically pleaded. Why? Because Section Order 6, Rule 2 says, plead and then prove, not prove and then plead. So all these things are important and they have to be taken into consideration when you try to introduce Section 11, Clause 4. Then one more provision which I have not discussed it in detail is jurisdiction. Section 15 to 20 of the Civil Procedure Code deals with jurisdiction. Please remember, when we read a section, we read it subjectively and we pronounce it subjectively. We pronounce it as jurisdiction, but you have to split the words. Jurisdiction means juris means courts, diction means authority. The authority of the court to try and entertain a particular matter is what is called jurisdiction. But just excuse me. So, as far as jurisdiction is concerned, it applies in various scenarios. For example, if you see Andhra University, located in Guntur, then how do you say, what is the authority of the Andhra University, sir? They are, I think Andhra University is called Nagarjuna University, if I'm correct. Then they have got they got their power over not only the university colleges, but all the colleges which are affiliated to it. What do you mean by that? That is, they can prepare the prospectus and also state what are the subjects offered by the particular university and what are the rules of admission and what is the fees you have to pay and how you can choose whether you have to attend an entrance test or you have to undergo counseling, and then the rules are prescribed. Then examination is and the subjects which are offered for every semester. Nowadays we are in the semester system, will be prescribed by them, and the syllabus also will be prepared by them, and the examination also is conducted by them. The degree is also given by them. That means they derive the authority by the creation of that university, and they have the jurisdiction or the wherewithal to conduct their own affairs. And nowadays we are having deemed universities also. That is, deemed universities means they are not affiliated anywhere. It is a university by itself. That means they can have their own rules and regulations, and they are given under a particular act. It is called the jurisdiction as far as the university is concerned. In the same way, you got the UGC, University Grants Commission. That means University Grants Commission controls all the universities throughout the country, including deemed universities, and the rules and regulations are framed by them and binding on all the authorities, all the universities. Then you take the nodal bank, what is called the apex bank, or you may call it the Reserve Bank of India. The Reserve Bank of India is the authority to dictate the banking policy, the terms of the FDIs, terms of the investments, terms of the money, various facilities that can be granted, and the overdrafts that can be granted, are the rules which govern the working of banks. RBI has got the power. So RBI exercises jurisdiction or authority over all the banks and regular banks and non-banking institutions also. Then you got the SEBI, what is called, as far as the share market is concerned, the regulating authority as far as shares are concerned is the SEBI. Then we have got what is called the Electricity Regulations Committee, or the uh, that Electricity Regulation Committee has got the power to frame rules and also stipulate as to what are the areas to which this regulation committee extends its powers. Then you got the various committees also. You got the AP the Telangana State Finance Corporation, Telangana Infrastructure Corporation, Andhra Infrastructure Corporation, Andhra Finance Corporation, so on and so forth. They all derive the authority by virtue of an act passed by the state. Then you got the Road Ravana Samstha, that is the Road Transport Corporation. They come directly under the government, but they are a corporation created under the relevant act, and where the question is the writ of that particular road transport authority extends to all the areas where the state has got the monopoly. Then you got the Life Insurance Corporation. Life Insurance Corporation is created by a statute by the central government. It's a separate corporation created by an act of parliament, and the rules and the LIC, the nodal body, has got the powers to exercise the powers as far as that act is concerned. Like that, what happens is various authorities have got various powers, and these powers which they exercise are the powers which comes within their jurisdiction or within their authority. Now coming to the subject in the proper perspective, section 15 to 20. Again, I repeat, section 15 to 20 discusses the chapter called jurisdiction. And from the legal point of view and from the point of civil procedure code, we have to understand jurisdiction as juris means courts, diction means authority. Authority of the courts to entertain and decide a particular matter is called jurisdiction from the point of civil law. Jurisdiction is divided to three parts. One is called pecuniary jurisdiction. Again, I repeat, pecuniary jurisdiction, Pecuniary. Pecuniary jurisdiction. Second one is territorial jurisdiction. And third one is subject matter jurisdiction. Then we'll go one by one, please. As far as pecuniary jurisdiction is concerned, here we are living in the Twin Cities. So it is governed by an enactment called the City Civil Codes Act of 1972. In 1972, when the City Civil Codes Act was passed, the civil courts, of course, before going to that, we must know the hierarchy as far as the subordinate courts are concerned. There are two types of courts. One is called subordinate courts, and another is called the High Court, or the higher judiciary, and the lower, or the district judiciary as it is called today. The district court comprises of it's a three-tier compartment. At the fulcrum, you got the district court, that is the principal district court and the additional district courts. And below the district courts, you have got the senior civil judges court or the additional senior civil judges court. And below the senior civil judges court, we have got the junior civil judges court. That is a three-tier compartment. As far as the lowest authority is concerned in the civil hierarchy, it is a junior civil judge. And above junior civil judge, you have got the senior civil judge. That is the middle berth of a train compartment. And then district court is a superior authority as head of the institution as far as the subordinate judiciary is concerned. Here, when the 1972 Act was passed, the cost of living was not that much. The jurisdiction of a junior court, or those days they used to call them as munsif, was only 5,000. And above 5,000 to 20,000, the jurisdiction of the authority was given to the sub-court or the subordinate court, or in the Twin Cities they used to call them as additional judges. Then above 20,000, the authority was given to the district courts to entertain the matter up to a particular limit. Then slowly what happened was it went on enhancing. Then they enhanced the value of the suit as far as junior court is concerned from 20 from I'm sorry uh, from 5,000 to 10,000, then to 20,000, then after that 50,000, and then latest is they've enhanced it to 3 lakhs. They enhanced it earlier was 3 lakhs. Till 3 lakhs you can file a suit before a junior court. Then above 3 lakhs till 20 about 3 lakhs the authority was with the senior court, and then after that the district court. But slowly they found that the cost of living has gone up, value of money has come down. So now latest is they have enhanced the jurisdiction of the uh, junior court to 20 lakhs. Till 20 lakhs, a junior court can entertain a matter. Above 20 lakhs to 50 lakhs, a senior court can entertain a matter. And above 50 lakhs, unlimited, it is a district court which can entertain the matter. So now, pecuniary jurisdiction is according to the value of the suit or value of the litigation which you have initiated, the court derives the authority. See, you may have a very good skill to write, draft, everything, but you must know in which court you have to file. For that, you have to go through the City Civil Courts Act if you are in the metros. But if you are in the districts, let us say, or the Moffisil, the Civil Courts Act applies. Of course, there was a disparity between the city civil courts and the civil courts which were existing in the districts. And most of the people now they have become they confine themselves to the place where they reside because of they say in Telugu sthana balam. So what they do is they practice in their own places. The advantage of practicing in their own places is that both the civil and criminal matters comes to the same advocate. Then these people in the districts, they started agitating and said, "Sir, why should there be a discrimination between the metros and non-metros?" So slowly what happened is today they have been brought on par with the city civil courts, whereby they say the same value applies as far as the districts are also concerned. So that means a municipal court or let us say junior civil court can entertain matters up to 20 lakhs. And from 20 lakhs and above up to 50 lakhs, it is a subcourt or what is called the senior civil judge. And above 50 lakhs, it is a district court which can entertain a matter. And please note that the rationale behind enhancing the jurisdiction was the High Court said we don't want to have all trash matters. We are all experts who can propound the Constitution, interpret the Constitution. We don't want these appeals, civil appeals. And that is the reason why they say you thrash out your matters at the threshold itself. That is the reason the jurisdiction has been increased. That is what is called pecuniary jurisdiction. Then we go to, of course, I'm not for a moment saying it is going to be static. Tomorrow, no one knows. The value may increase up to 30 lakhs for a junior court. But then we go to, I think I made myself clear, pecuniary jurisdiction means according to the value of the suit, according to the claim which has been made, up to 20 lakhs, a suit has to be filed before a junior court. Then you have got what is called territorial jurisdiction. You know, everyone is strong in his own place. And నేను అందుకే చెప్పాను తెలుగులో స్థాన బలం అనేది. Here, territorial jurisdiction is where the right to sue is accrued, or where the cause of action is accrued, where the property is located, or where the matter has to be thrashed out, and within whose authority your particular suit comes. It is what is called territorial jurisdiction. What do you mean by that? For example, suppose you are staying in Hyderabad, yourself and the defendant, but the property which is secured by mortgage, let us say it is located at Nalgonda. Then in that case, where should I file a suit, sir? I should file the suit at Nalgonda for the simple reason is I've got a charge over the property which has been offered as security, or let us put the other way around. The promissory note or the documents are executed at Nalgonda. Though you stay here, you cannot file a suit. Why? Because you will have to file the suit where the cause of action is accrued, not at the place where you reside. That is what is called territorial jurisdiction. But there is one way of getting over it. There, suppose let us say, the part of the cause of action is accrued at Hyderabad, let us say. What do you mean? Suppose you file a suit for partition, and in that, let us say one of the properties is located within the jurisdiction of Hyderabad courts, but some of the properties are at Nalgonda, some of the properties are at Khammam, some of the properties are at Mehboob Nagar. It is not necessary that you must go to every place and they knock at their doors. Either you can file a suit here in Hyderabad, or you can file a suit at Nalgonda, or you can file a suit at Mehboob Nagar, or file a suit at Khammam. That means wherever the right to sue has accrued, where it has given are the causes which has given rise to an action in a court of law, it is that court which has got territorial jurisdiction. Then how to keep it, sir, within the jurisdiction of this court? How to retain your client with you? You describe one of the properties at Hyderabad and say part of the property claim is at Hyderabad, so the Hyderabad court alone has got jurisdiction. No court can stop you from filing it. Then the last one is subject matter jurisdiction. I told you that we are in an era of specialization where tribunals are constituted. Whichever tribunal is competent to decide your matter, you have to go to that tribunal alone. You cannot go to a civil court. I told you family matters arising under the Hindu Marriage Act, Special Marriage Act, Indian Divorce Act, Guardian and Wards Act, Customs Act, so on and so forth. There, whatever tribunals are constituted for that particular purpose, you have to go there and you cannot go to a civil court. That is what is called subject matter jurisdiction. So these are the topics which I have missed by inadvertence. I have covered it today. Now we pass on to the interaction period, please.
Any questions?
Hello, sir. Good evening, sir.
Good evening, Nokia.
Myself Jamuna Tiwari, sir.
Jamuna Tiwari from Delhi.
No, sir, from Rajasthan.
Rajasthan, okay. Any other
Yeah.
word? Tiwari means Rajasthan. Please go ahead.
Sir, may you explain once again constructive res judicata?
Yes, ma'am. This is only a two-line rule which says all grounds of attack. Please note it. All grounds of attack and defense which might or ought to have been taken, if not taken, is deemed to be waived. What do you mean by that? All grounds of attack. Let us go one by one. Attack means where you want to attack the other side, go on certain admissions, go on certain correspondence, go on certain documents, and where you can attack the other side as per the rules of law, you must definitely plead it. That attack ground, you have to mention it in your plaint. If you don't mention it, it is deemed that you have given it up. Am I right? Then defense, all grounds of defense. For example, in the Contracts Act, you have got the doctrine of frustration, doctrine of novation, doctrine of remission, doctrine of alteration, doctrine of what is called doctrine of modification. All these defenses which are available to you, you are supposed to take it in the written statement. If you do not take it, or for example, you as the defendant in your reply to a claim pending before an NCLT or the National Company Law Tribunal, you have to take the plea of saying that the company has exceeded its objects clause and it's ultra wise and is liable to be set aside. Or let us say you want to lift the corporate veil as far as the company is concerned, that you have to attack, and you'll have to attack when you file a claim against the company. If you don't do it, or you don't take those grounds, either as a plaintiff or as a defendant, you cannot take it later. That is what, and it is deemed that you have given it up. Am I right, please? Yes,
Yes, sir.
yes, madam.
Yes, sir. Thank you, sir.
Then you take let us take a case of arrears of rent, please. Suppose let us say you are entitled to claim 3 years rent under the law. You do one thing, you claim 3 years back and you don't claim the subsequent rents for the other 2 years. It means you have given up those, and it comes to constructive res judicata. you have no claim over it, and which you should have done, you have not done it, then in that case, it is deemed that you have given up your claim and it is squarely decided by constructive adjudication.
Thank you, sir.
Welcome.
Sir, is there any way, sir, to say that we missed that fact that can it be rectified to
Sir, kindly be a bit clear, Mr. Muralidhar, I think.
find?
Please be clear, sir.
Yeah, yes.
Yes.
And resident ఒకసారి అయిన తర్వాత you can't claim again. And is there any way to again plead that due to some reasons it has not been
Then you'll have to lead
demanded?
strong rebuttal evidence to disprove the earlier judgment. Or you say there's a
Right.
change of law, change of circumstances, or change of subsequent events, or change of law, change of amendment, which has rendered the previous judgment illegal or unlawful. Only in those cases, not otherwise.
Shruti Ketan.
I understand. Sir.
Welcome.
Shruti Ketan.
Shruti Kirtani.
Kirtan. Shruti Kirtan. Is she available? She asked, sir, please explain about judgment and decree.
Yeah. Here I have explained so much, but anyhow, I don't mind explaining it again. Judgment means it is pronounced or it's spelled in two ways: Judgement or Judgment. Judgment means it is two words. Judge means presiding officer or a presiding judge, or meant means dicta of a presiding officer vis-a-vis the facts of the case, the pleadings, facts, documents, and other things are called judgment. For example, the admissions, contradictions, inconsistencies, the case law which has been cited, based on which the pronouncement is made, or tirpu is given, or faisala is given, is what is called a judgment. That is a pronouncement by a judicial officer in the course of his office vis-a-vis the facts of the case and the documents and the case law on that subject is what is called a judgment. But as far as a decree is concerned, decree is supposed to be a distillate of the judgment. I gave you an illustration also. You go to a fruit juice dealer and order for a cane juice, let us say, sugar cane juice. Then what the cane juice dealer does is he first crushes the cane and then takes the juice and filters it. And then the filtrate which comes in this glass is called this decree. And the residue which is on top is thrown out. So what is important in a civil court is what is executed is only a decree, and what is executed is only a decree, and judgment is only as far as the facts are concerned. Am making myself clear to you, please? And I also told you that there are two decrees in past in certain matters: preliminary decree and final decree. For example, partition suit, mortgage suits, suits for accounts, and suits for eviction and mean profits, so on and so forth. So preliminary issue will say that you are entitled for a particular thing. How you are going to get that particular thing? The question is by a judicial process. That is what is called a preliminary decree, and ultimately final decree is passed. Yes, I'm making myself clear.
Question on the A. Srinivas Rao garu. Mr. A. Srinivas Rao, is he available? Mr. A. Srinivas Rao?
Yes, sir. Yes, sir. Very good
You
evening,
have
sir.
asked some question over in the chat box. Please go ahead.
Yes, sir. Thank you for giving the opportunity, sir. It was a very nice session, sir. To
Thank you.
precise. Yeah, and sir, my question is relevant to. I mean, it's related to the acts which we have been discussing about. So, first of all, you said that in case if you have a issue which is related to societies,
Yes.
you cannot go to district courts. Rather, you have to redirect it to the society's registrar.
Yes.
So, is it only relevant to the caste societies or
It applies to
societies which are related?
it applies to house building societies, cooperative societies, and other societies where the registrar of societies can depute the matter to arbitration before the concerned deputy registrar. That is provided, and the bar for a civil suit is again in the Societies Act, Section 61. And if you see the Societies Registration Act, Section 23 is the section which says dispute between a member and a member, members and members, member and the society. That the question is it has to be adjudicated by arbitration. before the under the Arbitration and Conciliation Act or before the Principal District Court. But a junior court or a sub court cannot entertain that matter, please.
Thank you for clarification, sir. So,
Yes.
following up with the same subject and the topic. See, for example, if a society is registered, then probably yes, whatever you're saying, we can go to the society's register.
Yes.
But
Yes.
in case if the society is not registered,
Then society is
or
not.
if the
Yes, I'm coming to that. The society is not registered. You have got a provision called Order 1, Rule 8 under the Civil Procedure Code, which says suits in a representative capacity. Either it can be sued by two or more persons on behalf of the other body of persons, or you take the permission of the court under Order 1, Rule 8 to represent that society in a representative capacity through the person in charge who is conducting the day-to-day affairs. You will have to resort to Order 1, Rule 8, please.
thank you, sir. Thank you.
Mr. BSR, Srinivas Reddy garu. Mr. Srinivas Reddy, are you there, sir? Mr. Srinivas Reddy garu. Are you there? I don't think so he's there, but there is a question asked from Mr. BSR. Srinivas Reddy garu, here is the question.
As far as this particular question is concerned, addition of parties is done. Will the res judicata applies in such a case? As far as res judicata is concerned, I made it very, very clear. It not only binds the parties in the earlier suit, but also the subsequent parties who are transferees in interest or who are legal representatives or who are assignees or who are not on record in the former suit. Whatever the other side, their predecessor is bound, they are also bound by that, though they are not parties, please. That's what is the explanation.
Any more questions? Thank you. Any more questions from anyone?
Sir, regarding judgment and decree, what comes first, sir?
First comes the judgment, next comes the decree.
Okay, thank you.
Anybody else?
Okay, thank you.
What
Right,
is
right.
the grounds of attack, sir?
Grounds of attack is, suppose, let us say, in a particular case under various enactments, you've got the various grounds on which you can pin down the other side. For example, suppose in a company matter, I'm just giving you a case. In a company matter, suppose, let us say, the other side, which is a company, has crossed its objects clause and gone beyond the objects. It is ultra vires and the corporate veil can be pierced. In those cases, you can always attack it by saying, sir, it has gone beyond the objects clause, it is illegal. Then you've got various grounds of attack. For example, adverse possession. In Hindi, they call it as akrama daru. Akrama daru in Telugu, and in Hindi they say najais kabza. That is, if you are in possession of a property for a continuous period of 20 years without any interruption, without any obstruction, or without any objection from anyone, your possession is safeguarded. That is, though you may not have title, but you can safeguard your possession on the ground of adverse possession. This is referred to in the law of easements and prescriptions act. Long possession for 20 years without any interruption confers what is called possessory title. And in jurisprudence, it is said possession is 9 points of title. Why is it called 9 points, sir? Because that one single negative point is whenever the true owner comes, establishes his title or right to the property, that 1 point will have precedence over your 90 over the other 9 points which you have got in your favor. So that is how it is explained, sir.
Any more questions?
Just now you said 9 points of
9 points of
title, sir.
possession is 9 points of title. That means that is, you can safeguard your possession against everyone if you are able to show that for 20 years you have been in long possession, no one has obstructed, no one has objected, you are in continuous possession. Then in that case, you have got a possessory title, though you may not have a document. But when the true owner comes out and establishes his title and the rights against you, his 1 point will have precedence over your 9 points of position, please. Am I making myself clear to sir?
That is within 20 years, sir.
20 years, 20
Within
years.
20 years.
20.
Section 144. Somebody is asking.
I'm sorry, sir, it's not 20 years, it's 12 years. Sorry.
Srijo.
Is it 12 years, sir?
12 years, sir. I'm sorry, it's not corrected.
Srijo. Section 144.
144 deals with what is called the principle of restitution. Whenever the judgment and decree of the lower court is set aside by the appellate court, the party who has succeeded in the appellate court has to be put back in the same position which he was prior to his disposition or otherwise. That is what is called reversal of a judgment. Reversal of a judgment and decree by the superior court, the lower court is bound by that and can put back a person into possession if he has been evicted or thrown out of the property. That is the ambit of section 144. It is not contained in any of the orders. It's only the substantive law, that is 144. That is what is called restitution. Restitution means restore, retrieve, put back in the same position which a person was earlier. That is what is called restitution. But the condition is the judgment and decree of the lower court should have been set aside by the appellate court. Then in that case, a person is entitled to be put back into possession or to the same position as if a decree has not been passed against him. That is called restitution.
Sir, what is memorandum of appeal?
As far as memorandum of appeal is concerned, that means what are the grounds where the lower court has committed mistakes, what are the grounds on which the lower court has not taken cognizance of the admissions, the contradictions, inconsistencies, or misinterpreted the case law which has been cited, or has sidetracked itself from the real facts of the case, or has given a 3D judgment where it is not your case or the case of the other side, but it has gone at a tangent. Then in that case, you can file an appeal and you file it in the form of grounds. I told you, I think that when I discussed this also, is that the appellate court which is seized of the matter can look into the matter afresh and discuss it. Memo of grounds means the grounds on which you are aggrieved and say that the lower court has committed mistakes is a fault-finding mission. That is what is called appeal. Or in Urdu, it is called murafa.
Sir, anybody else? What is second name? Betty Ram Mohan garu. Ram Mohan. Sir, explain about second appeal.
Yes, I'm sorry, sir. I think, thank you very much. Second appeal lies under section 100, Civil Procedure Code. That means earlier to 1976, second appeal could be filed as a matter of right and no need of getting through the admission process. But in 1976, they found litigations are being prolonged forever. There should be some end to the litigation. As far as your facts are concerned, the final fact-finding authority is the first appellate court. As far as the High Court is concerned, it does not appreciate facts or go into facts. You have to call out or mention the substantial questions of law which has been misinterpreted by both the court, that is the lower court as well as the appellate court, on which you want the High Court to exercise its jurisdiction under Section 100 Civil Procedure Code. And it is not available to you as a matter of right. It has to go through the churning process. It is subject to admission before the High Court, and the High Court, when it finds that substantial grounds are made out, then in the order the judge says admit. Substantial questions of law are contained in para 4, and they are perfectly satisfactory, and it appeals to the discretion of the court, and the second appeal is admitted, and stay also is granted in case stay is asked. And tomorrow, when it comes up for final hearing, you have to argue only on the substantial questions and not on facts. Please remember, after the amendment in 1976, questions of fact will not be gone into in the second appeal. So an appeal which is filed against the judgment and decree of the appellate court on substantial grounds of law is what is called second appeal.
Sir, anybody else? Shall we conclude the class? All right, let's conclude the class for today. Any more questions? Please hold your questions. Sir, Mir Ali Khan Mir. Sir, jurisdiction in chit fund cases.
As far as the chit funds are concerned, a special act has been brought about last year saying that civil suits cannot be filed. They are subject to arbitration, and the matter has to be addressed to the registrar of societies, who deputes a registrar from his office, and he sits in adjudication and passes an award what a civil court can pass. And then that is what is called it's also called ADR, alternate disputes resolutions. The advantage of going through the registrar's process is the court fee that is paid, or the amount that is paid towards the litigation, is only 50 rupees, which is deposited in the treasury. But the process followed by the arbitration, that is by the registrar, is absolutely faulty. Why? Because they literally threaten the defendant and say amount istava sastava, and you don't file the written statement or counter on the first date of hearing, automatically the award is passed. And please remember, the process is, unfortunately, the counsel who is appearing for the bank or the chit fund writes the judgment, and the registrar only signs it. But of course, it's subject to appeal before the cooperative tribunal, where you can fight out the matter.
Anybody else?
Namaskar.
Yes.
Nagachandram.
Namaskaram.
ఇంతవరకు అడగలేదు,
I am Naga-
అడగండి. చెప్పండి. ఎస్ మిస్టర్ నాగచంద్ర,
ఇవాళ అడగలేదు.
అడగండి నాగచంద్రం గారు.
Sir, please ask in the English so that everybody will understand.
ఎస్ మిస్టర్ నాగచంద్ర.
Sir.
ఎస్ ప్లీజ్.
సెకండ్ అప్లికేషన్ ఎంత ఉంటుంది సార్?
పాడన్ ప్లీజ్ బి క్లియర్.
సెకండ్ అప్పీల్ కు లిమిటేషన్
రిజాయిండర్
సెకండ్ అప్పీల్ కు లిమిటేషన్ ఎన్ని రోజులు ఉంటుంది?
దేనికి?
సెకండ్ అప్పీల్
As far as second appeal is concerned, it is 3 months, please. 90 days. 90 days.
17 years back. 17 years back, judgment will be came, sir.
Sir, appeal మీకు 30. Sir, if you are going to second appeal, it is 90 days from the date of judgment of the appellate court. 90 days, 90.
Before judgment, sir.
Yes, sir. That is from the appellate court judgment. It is 90 days. If it is going to be an appellate court, as far as civil matters are concerned, if you take the family court matters, it is 60 days if there are no family courts to the High Court, or if there are family courts, it is 90 days to the High Court. If it is from a regular family court, please.
Sir, there is another question which is Anjali Verma. Here is the question. All decrees and all judgments are not all judgments are all decrees.
Please remember, all judgments are the pronouncement made by a judge or a presiding officer. But as far as a decree is concerned, sum and substance of the judgment is what is called the decree. So both of them are like husband and wife. They live together. There is no question of separating the wife from the husband or husband from the wife. But as far as your other thing you have asked, whether the decree is separate or decree and judgment are separate entities, no. They are like twin brothers. They live together. One cannot live without the other. Yes, Miss Gauzia.
She has a question now again.
Sir, what is the substantial question of law?
My colleague is laughing because every time we expect a question, that's why I said I was surprised. Till the end, I was really pained to see that Gauzia has not asked any question. Here, as far as substantial question of law is concerned, suppose, let us say, your case involves a judicial interpretation on a particular aspect, and whereas there are contradictory judgments of various high courts, and the court below that, the appellate court, has not decided it properly or not come to a proper conclusion, and it requires judicial interpretation of the highest order, and so that there may not be any confusion later, and substantial question differs from facts and circumstances of each case, and your knowledge or your wisdom lies in framing the substantial questions of law, and questions of law differs from various facts and circumstances, please, and the various scenarios. Yes. Next.
Any more questions? Or shall we conclude the class? Anuradha Bakaraj Garu. You want to ask
Yeah.
any questions?
Yes.
Yes, madam.
Sir, is the time stipulated for a judgment and a decree to be pronounced?
Pardon?
Will you please be loud, madam? It's not audible.
Sir, is there any time limit?
See, as far as judgment and decree is concerned, I told you in order 20, earlier, the court can pass a judgment immediately or reserve the case for judgment, and 14 days time was given to pronounce a judgment. But later on, they felt our courts are so busy and they're dealing with the cases every day, and they're only interested in work and nothing else. They said the legislators felt some more time has to be given to the judges to pass a judgment. That is the reason the amendment of 2002 said a judgment which is reserved a judgment can be passed within 60 days. But we are seeing by experience no judgment is passed before the expiry of 6 months. Even the High Court is taking 1 year or 2 years to pass a judgment. The question is, one of the ways of getting over the statutory period is they ask the advocates to file a petition for reopening and say, sir, we want to argue it again. Some more important facts have to be argued. Then in that case, you get a fresh period of 60 days. Then again, what happens is, again another reopening petition is filed. Again, you get 60 days. Like that, 1 year gets exhausted. Please remember, wherever there's a rule, there's an exception. How to overcome it? The judge has got his own ways of doing it. As far as a decree is concerned, decree is prepared 7 days from the date of judgment. Though the date mentioned in the decree will be the date of judgment, but they take 7 days so that party is given an opportunity of filing the MC and FC, that is memo of cost and fee certificate within 7 days. A decree is prepared accordingly. And no court prepares a decree within 7 days. Sometimes they take 1 year, 1 month, 2 months, 3 months also. That's the reason an amendment has been brought about when you file an appeal under Order 41 to say the copy of the decree need not be filed. You can file an application to dispense with filing of the decree copy and give an undertaking that the decree copy will be filed as and when obtained. Am I making myself clear, Mrs. Anuradha, please?
Yes, sir. Thank you so much.
Welcome.
Thank you. With this, we conclude the class today and see you tomorrow again. Bye-bye.
Tomorrow specifically factor.
Sir, today's session super, sir.
Thank
Thank
you. Thank you.
The judicator is clarity. Every word neatly explained, sir.
Sir,
Judgment to
sir,
judgment.
yes, sir. Sir, tomorrow one more announcement is, tomorrow I'll be
Thank you,
dealing with the specific relief factors.
Okay, thank you, sir. Thank you, sir.
Tomorrow we have a specific relief act. I was told by Santhanam sir, and we're coming up tomorrow. And even CPC also will be there, which are left over.
Sir, only
Noma?
CPC.
CPC is over already.
CPC is almost over. Almost over. Some things left over. It will be covered also.
CRP, no, sir.
CRPC in the end.
CRPC Next is contract tax. Anybody is interested in contract tax?
Specific.
Anybody is interested in contract tax?
Yes.
I'm interested in contract tax. So we are coming with contract tax also. Masterpiece for everybody. All right. Thank you. See you tomorrow again. Bye bye.
Okay, sir.